Imagine you just lost your mother. You're still in that foggy, exhausted place where grief feels like it's sitting on your chest. And then the phone rings. It's a debt collector. They're calling about your mother's medical bills. They say the account is past due. They say the hospital needs payment. And then, almost in passing, they say your name and suggest that you may be responsible for covering this. You hesitate. You don't know the exact amount. You don't know if she had insurance that should have covered it. You don't know if this is even real. But the collector sounds confident. Official, like it's already settled. So you think, what if I'm actually responsible for this? What if arguing only makes it worse? That right there is the moment. That moment of doubt, that pause, is exactly what some collectors are counting on. Here's what this video is going to do. We're going to break down why collectors can contact you over bills that aren't legally yours, what the law actually says versus what collectors want you to believe, and the exact sentence you can use the next time a collector calls so you don't accidentally make things much worse for yourself. Because that sentence, most people don't know it. And not knowing it costs people real money. Let's get into it. When a debt collector calls, most people immediately assume two things. 1. If someone's calling, the debt must be legitimate and real. 2. If the debt belonged to a spouse, a parent, a sibling, someone in their family, then on some level, it might be their problem to deal with. Neither of those assumptions is automatically true. And the second one, in particular, is where people get seriously burned. Think about what happens after someone dies. Their family is grieving. There might be a lot of financial confusion, insurance claims, bills arriving in the mail, accounts to close. It's overwhelming. And into that confusion, a collector calls and says, "This bill is unpaid, and we need to resolve it." Now here's the thing. The collector may be calling you specifically, using your name, maybe even implying you have a legal obligation. But implying and legally true are two very different things. The fear of making it worse, of saying the wrong thing, of getting sued, of damaging your credit, keeps a lot of people from stopping and asking the most important question: wait, why exactly do I personally owe this? That moment of not asking, that's where the trap closes. Let's talk about why this happens in the first place. Debt collection is a business. When a collector purchases an old debt or is working a delinquent account, they're trying to get paid. And the easiest way to get paid is to find the most reachable, most responsive, most emotionally connected person and contact them. That person is often a family member. Surviving spouses are particularly vulnerable. When one spouse dies, the other is grieving, often disoriented with finances they may not have handled before, and suddenly receiving a wave of paperwork and calls. A collector who calls a widow or widower 2 weeks after a death is not calling randomly. They know that person is likely to answer, likely to be emotional, and likely to be uncertain about what debts they might actually owe. Same thing happens with adult children of elderly parents. Dad passes away with medical debt. The adult children get calls. The collector says the bill is unpaid. The implication hangs in the air. Someone needs to take care of this. Here's the hard truth. A collector contacting you does not automatically mean you are legally on the hook. The Consumer Financial Protection Bureau, the CFPB, which is a real federal agency that handles consumer financial issues, has noted that family members of deceased debtors often get contacted by collectors, but that contact does not equal legal responsibility. Being asked is not the same as being obligated. Some collectors know this distinction perfectly well. They're hoping you don't. This is the part where a lot of people get confused, so let's go through it carefully. In the United States, when someone dies, their debts don't just disappear, but they also don't automatically transfer to their relatives. What actually happens is that the debts become a claim against the deceased person's estate. The estate is basically everything they owned when they died: their bank accounts, property, assets. If there's money in the estate, creditors can make claims on it through a legal process. That process is called probate, and it's handled by the courts. So if your mother dies with $20,000 in credit card debt and $30,000 in savings, the credit card company may have a legitimate claim against that $30,000. But that's different, very different, from the credit card company having a claim against you, her adult child, out of your own pocket. The key rule, under federal law and most state laws, is this: you are not personally responsible for a deceased person's debts simply because you are their family member. Now, and this is critical, there are real exceptions. If you were a cosigner on a loan, you are legally responsible. If you had a joint account with someone, you may owe that debt. Some states have what are called filial responsibility laws, which can create limited obligations for adult children related to certain care costs, but even those vary widely and are not universally enforced. And spouses in certain community property states may have shared responsibility for debts incurred during a marriage. These exceptions are real. They matter. And if you're not sure whether one of them applies to you, that's worth looking into, potentially with a lawyer or a nonprofit credit counselor. But the default rule, the baseline, is that family members are not automatically on the hook for each other's debts. Medical debt specifically is another area of major confusion. Hospitals can bill aggressively. Bills can be enormous. And a lot of people don't know what their insurance actually covered until weeks after treatment. That uncertainty creates a perfect environment for pressure. Just because a bill arrived with your name near it, or your name was mentioned on a call, doesn't mean the debt is legally yours. Let's talk about what some collectors actually do in these situations, because once you can see the tactics, they lose a lot of their power. Making it sound urgent. The collector implies there's a deadline. Pay now, or something bad happens. The account will be escalated. A lawsuit is coming. Your credit will be wrecked. That urgency is designed to short-circuit your thinking and get you to act before you fully understand the situation, making it sound already decided. The collector speaks with authority, like the fact that you owe this has already been established, you just haven't caught up yet. They don't ask, do you owe this? They say, we're calling about your balance. The framing assumes the conclusion, playing on guilt and moral obligation. This one is particularly powerful with grieving families. The implication, sometimes stated directly, is, your mother left this debt. Don't you want to do the right thing? It reframes a legal question as a moral one. And for someone who is grieving and loves their family, that framing hits hard, using confusing language. Some collectors use terms like responsible party, or say that you're listed on the account in ways that sound official but don't actually tell you whether you have a legal obligation. Confusion benefits them. Clarity benefits you. Pushing for payment before you can think. If you pay something, anything, before you understand the situation, you may have just created a legal acknowledgement that complicates things later. Some collectors want payment, any payment, quickly, for exactly this reason. None of this is hypothetical. These tactics are documented. The FTC and the CFPB have guidance specifically warning consumers about pressure tactics in debt collection because they're real and common. Here are the concrete warning signs. If you're getting any of these during a collection attempt, slow down before you do anything. They can't clearly explain why you specifically are legally responsible. Not why the debt exists. Not why the original person owed it. Why you, with your name, your financial situation, are personally on the hook. If they can't answer that clearly, that's a serious red flag. They won't send you documentation. Under federal law, specifically the Fair Debt Collection Practices Act, debt collectors generally must provide you with written verification of the debt if you request it. If a collector is pushing hard on the phone but balking when you ask for something in writing, pay attention to that. They pressure you to pay immediately, right now, on this call. Legitimate debt situations don't typically evaporate if you take 2 days to verify information. High-pressure urgency to pay in the moment is a tactic, not a legal requirement. They appeal to your emotions more than they provide facts. If the whole conversation is about how the deceased person would want this resolved, or how the family should come together to take care of this, and very little is about actual account details, dates, amounts, your specific legal connection, that's a manipulation play, not a factual conversation. The account details are vague or inconsistent. They can't tell you the original creditor, the account number, the exact amount, or the timeline. Legitimately owed debts have documentation. If the information keeps shifting or doesn't hold up to basic questions, that matters. Here's the practical section. Let's make this as clear and usable as possible. Step 1. Do not panic. Easy to say, genuinely important. A panicked person makes fast decisions. Fast decisions in debt situations are often bad decisions. The collector calling you does not create an emergency. It creates a situation you need to understand before you respond. Step 2. Do not admit the debt is yours. Not on the first call, not before you have documentation, not before you understand your actual legal situation. You can acknowledge receiving the call without confirming anything about the debt itself. These are different things. Step 3. Do not agree to pay anything on the spot. This is critical. Even a small, good faith payment can be interpreted as acknowledging the debt. Before any money changes hands, you want to understand what you're actually paying and why you're legally responsible for it. Step 4. Ask for written validation. The Fair Debt Collection Practices Act gives you the right to request written verification of a debt. If you send a written request for validation within 30 days of first contact, the collector is generally required to stop collection activity until they provide it. That gives you breathing room. Step 5. Ask directly, why am I personally legally responsible for this debt? Not is the debt real? Not does my family owe this? Why am I, specifically, legally on the hook? If the answer is vague or relies purely on your emotional relationship to someone, that's information. Step 6. Keep records. Write down dates, names, what was said, what was claimed. If letters arrive, keep them. If calls come in, note them. If something goes wrong later, documentation is your best friend. Step 7. Verify before you send money. If you genuinely want to understand your situation, especially around estate debt after a family member dies, there are free or low-cost resources available. Nonprofit credit counselors can help. Some legal aid organizations offer free consultations. The CFPB website has clear guidance on debt collection rights. There is no reason to pay first and investigate later. Do it in the other order. You were promised this, so here it is. If a collector calls about a debt that you're not sure is yours, here is a simple, clear sentence you can use. I am not confirming that this debt is mine. Please send me written documentation showing the debt details and explaining why you believe I am personally and legally responsible for it. That's it. That's the sentence. You're not being rude. You're not refusing to deal with the situation. You're simply not handing the collector something before you understand what's going on. Here's why it works. It's calm, it's specific, and it doesn't give them anything to use against you. You haven't confirmed the debt. You haven't agreed to anything. You've made a clear, documented request. And a legitimate collector should have no problem fulfilling it. If they push back hard, if they get aggressive, if they say there's no time for that, that reaction itself is information. A real, verifiable, legally owed debt can survive 2 business days of waiting for documentation. Keep that sentence somewhere easy to find. On your phone, on a note in your wallet. You might be surprised how often you'd use it. The biggest mistake is paying something before you understand why you actually owe it. Not because paying debts is wrong. Paying debts you genuinely owe is the right thing to do. But paying a debt collector before verifying whether you're actually legally responsible can create real problems. First, you may have paid something you didn't know. That money is very hard to get back. Second, a payment can be used as an acknowledgement that the debt exists and is yours. In some states, that can restart a statute of limitations, meaning a debt that might have been too old to legally collect suddenly has new life. This is a documented, real issue under consumer debt law. Third, paying one thing without understanding the full picture can lead collectors to return with more. There's also a closely related mistake, saying too much on the phone. Saying things like, I know my mom had some unpaid bills, or we've been meaning to deal with this, even innocent, conversational statements, can be interpreted as acknowledgments. You don't owe collectors your thoughts. You owe them a specific question. Show me why I personally am legally responsible. Shame and fear are often what get people talking too much. They're embarrassed. They don't want conflict. They want to seem cooperative. Those are understandable human feelings. But a debt collection call is not the right place to act on them without information. A debt collector contacting you is not proof. It is not a court order. It is not a legal judgment. It is a phone call or a letter from someone who wants money, and whose job is to make that call feel as inevitable and urgent as possible. You have real legal rights in this situation. The Fair Debt Collection Practices Act exists specifically to protect consumers from abusive, deceptive, and unfair collection practices. It's a real federal law. The CFPB enforces it. And one of the clearest things it protects against is collectors misrepresenting who actually owes a debt. You are allowed to ask questions. You are allowed to request documentation. You are allowed to take time before responding. You are allowed to say, "Prove to me why I personally owe this," in writing. The moment you know that, the moment you really absorb that asking for proof is not aggressive, it's just reasonable, the whole dynamic shifts. You're not on the back foot anymore. Being targeted by a collector doesn't make you a debtor. It makes you someone who received a phone call. What happens next is something you have real influence over, as long as you slow down before you respond. If you're currently dealing with a collection situation, whether it's something that may be yours or something you suspect isn't, check out the CFPB's website, cfpb.gov. Their consumer protection resources are free, clear, and genuinely useful. And if the situation is complicated or involves an estate, a free consultation with a local nonprofit credit counselor or a legal aid office can be worth more than hours of searching online. You're not alone in this. And you're more protected than most collectors want you to know. Before you go, have you ever been pressured to pay a bill you weren't sure you actually owed? Drop it in the comments. Because I guarantee you're not the only one with a story like that. And this is exactly the kind of conversation that helps other people feel less alone when it happens to them.